Hello, my name is George Benoy, and today I will be covering last will, healthcare directives, and trusts. Before I start, let me state that I am not a licensed legal provider, and I would definitely request you to consult a licensed attorney in Georgia and, if applicable, in India as well before taking action. Now, let's get started. Why does estate planning matter? When we talk about estate planning, it is important to recognize that immigrant families, especially those with assets and relatives in more than one country, face unique challenges. We often assume that our intentions are clear, that everyone knows what's fair. But here's the reality: neither the US law nor Indian law honors intentions that aren't documented. Let's look at a few myths we often hear. I'm too young. Tragedy doesn't wait for age. Estate planning isn't just for retirees, it is protection for your loved ones right now. Another point is joint property covers everything. My wife's or my husband's name is on the property, so it covers everything. Not necessarily. If both spouses pass away together, or if the ownership documents aren't unclear, assets can still go through probate. And for property in India, joint ownership doesn't automatically transfer without clear nomination or a will. And again, a common saying is everything automatically goes to my spouse and children. That's a big one, but unfortunately not true. Without a will or trust, the state law will decide who inherits and in what order. In some cases, children and parents of the deceased may have competing rights. Note: US law requires formal documentation. Verbal agreements, family understandings don't hold legal weight here or in India. So, if you are an immigrant or have cross border assets like in India and US, your planning needs to bridge the two systems. That means clear US documents for your US assets and a properly executed Indian documents for your assets there. Both must be consistent and so they shouldn't contradict each other. This is about clarity, protection, and love, ensuring your intentions cross borders as smoothly as your family life has so far. Let me share a story that illustrates just how important estate planning can be. Not for the wealthy, but for anyone with loved ones. Let's take the case of Vincent and Stella, a young couple in 30s, energetic, devoted parents, two beautiful kids aged 7 and 4. They had busy lives, juggling careers, family routines, thousand little things that come with raising children. Like many young parents, they often said, "We'll get around to it someday," when the topic of will came up. Then one tragic evening, their lives changed forever. Vincent and Stella were driving home from a weekend trip when their car was struck by a truck on the highway. Both of them died instantly. Their children were left in shock, and as painful as it is to say, suddenly without parents. What made this tragedy even harder was what came next. Vincent's parents lived in India. Stella's sister lived in California. Both sides of the family wanted to take care of the children out of love, but also out of deep cultural and emotional bonds. Unfortunately, since Vincent and Stella did not have a will, there were no clear guardian legally designated for their children. The months that followed were filled with confusion and conflict. The family struggled with the two legal systems, Indian and US, different guardianship laws, requirements, expectations. Emotions ran high, the paperwork piled up, and the children's future hung in a limbo. For a time, the courts had no choice but to place the children in a temporary foster care while it reviewed the competing petitions. Imagine that. Two little kids, already grieving their parents, now living with strangers, waiting for adults and courts to decide where they belong. Eventually, the courts granted custody to Stella's sister, but only after months of hearings, international legal coordination, immense emotional strain for everyone involved. Lesson: All of this could be avoided with one simple act of foresight: naming guardians in a will. Had they done that, the children's care would have been clear from day one. No disputes, no delays, no foster care. This, their families could have focused on healing instead of navigating the legal chaos. The lesson here is powerful. The planning is an act of love. It is not just about property or paperwork, it is about giving your family clarity, protection, and peace of mind when they need it most. So, when we talk about estate planning, it's not about money, it's about compassion. It's about ensuring that the people we love are never left in uncertainty, even in our absence. Let's clarify a point that often creates confusion for families with assets both in US and India. Technically, your US will can include Indian assets. There's nothing illegal about it. But in practice, when it comes to execute that will in India, your executor has to go through an Indian court process called probate. This process involves submitting your will for authentication in an Indian court, the US will in Indian court, get it recognized under the Indian Succession Act, navigating additional steps as translation, notarization, possible challenges about validity, jurisdiction. This could take months or even years, and it often delays access to the property or bank accounts in India. That's why most estate planners always recommend creating a separate India compliant will, one specifically for your Indian assets. It is written under Indian law, executed by Indian witness, and handled by an Indian executor. This keeps things clean, simple, and much faster to administer locally. In short, your US visa will cover your US assets, and your Indian will cover your India assets, the property, ancestral holdings, all that. Both wills can coexist as long as they clearly reference each other and state they apply only to the assets within their respective jurisdictions. Today's focus, we plan on US based planning. The protecting your US assets, naming the guardian for your children, setting up healthcare directives and trusts under the US law. Think of it this way: the US plan protects your assets here, India plan preserves what you have built back in India. But together, it gives your family clarity and peace of mind across the borders. Now let's walk through what a will actually does. How to make sure it's done right. A will covers how assets are distributed. Your will determines who receives what, your home, bank accounts, investments, personal items. It's your written voice when after you're gone. Without it, the state law decides, and it may not align with your wishes. Every state, including Georgia, has its own inheritance laws. So your will ensures you and not the court chooses your beneficiary. Let me give some examples. In Georgia, if someone dies without a will, they leave a surviving spouse and children, the estate is divided equally between the spouse and children. But there's a catch: the spouse is guaranteed at least one third of the estate. So, whatever is remaining, the two-third is what gets split across, uh, let's say, three children, four children. That's how it is. And another point to notice is Georgia is one of the few states in US that don't impose an estate tax or inheritance tax. New York, Illinois, they all charge those taxes as well. Again, what I'm just saying is that US will has got some state specific nuances as well. Something to keep in mind, but doesn't really affect much of the language unless you specifically want to override or make it very clear. Now, guardianship of minors. When you have children under 18, this is very important. You have to name primary and backup guardians, people you trust to raise your children if both parents pass away. Don't write names, tell them, talk to them, tell them why you chose them. And without this step, the court will decide who raises your children, and that process can take time and cause conflict. Another one in the will is naming an executor. Who is an executor? Your executor is a person who carries out your wishes. They're not your guardian for your children. They're not the ones who will uh, essentially take care of your children. For example, if you have some credit cards to close out, or if you want to manage property, or you want to liquidate assets and move to some other account, they are the ones who will take care of all that. Choose someone who is responsible, trustworthy, and organized. It's also wise to name an alternate executor in case the first one is not able to serve, either because they are not in the country or they have health issues or whatever be the reason. Make sure that you have a backup. Now, your US will typically covers your property in US, your investments, personal belongings. What it does not typically control is things that have named beneficiaries. For example, life insurance, you name a beneficiary. 401k, you mention your beneficiaries, or IRAs, or even in some investment accounts, you can basically say transfer on death and you can give a form. All those things are covered by that. That takes precedence. What is not covered by using such instruments is what is covered by your will. So it's very essential to not just prepare the will, make sure that you go to each of those accounts and review your beneficiary designations there as well. In Georgia, a will requires two adult witnesses, both present when you sign. And to speed up the probate, you can also provide a self-proving affidavit, a short statement that says that your witnesses signed, confirm that they saw you sign it, and all that. This prevents a court from trying to track down witnesses years later, saving time and cost. So they don't have to actually say, "Hey, did you really visit?" Because you have already done that, and they are notarizing that statement as well. Now, understanding probate and why to minimize. Probate is that legal process of proving your will and transferring assets after death. It's public. It takes months. It involves court fees. Uh, I'm not sure how many of you have gone through this, but this is a painful process. And this is why estate planning will focus on minimizing probate. So if things can take quick decisions without going through the courts, that's faster and simpler. Now, a well crafted will is what you want to look for. It will bring clarity when your family needs it the most. Let me take an example. Let's talk about Paul and Lily. They were ordinary couple, middle class, hardworking, raising two kids, managing a mortgage, and planning their next family vacation. Like many of us, they assumed that there would be a time to get their things in order. Writing a will just didn't feel urgent. Then one morning, Paul didn't wake up. A sudden heart attack took him, completely unexpected. Lily was devastated. Overnight, she found herself a single parent trying to hold a family together while managing her own grief. In the middle of that emotional storm, she also had to deal with something that she never anticipated: paperwork and legal red tape. Paul had been the primary account holder for most of their finances. And as in most families, typically the husband takes that role. The bank accounts, the investment, and even the mortgage. Because there is no will naming Lily as the executor and giving her legal access, the banks wouldn't release any funds. Everything was frozen pending probate. The court process to validate the assets, determine legal authority, just because you're the spouse doesn't give you that. Weeks went by. The bills keep coming on, and you have to keep paying the bills, right? Lily couldn't access the family savings or insurance proceeds without the official court documents. So she had to borrow money from relatives just to cover the basic expense for her children. What should have been a time to focus on healing became a time filled with anxiety, forms, court dates, uncertainty. It took months before the probate court finally granted her access to Paul's accounts. By then, the emotional toll was immense. She described it as grieving twice, once for her husband and once for the stability they lost because of their legal delays. Let's cover the healthcare or health directives. When you start thinking about estate planning, we often focus about finances, but your healthcare wishes are just as important. What happens if you are unable to speak for yourself due to an injury or illness? Who makes those decisions? That's where the healthcare directives come in. Advanced Healthcare Directive, or more specifically in Georgia, there's a document called AHD. It's an umbrella document that combines two things. One is a medical power of attorney, and second is a living will. So when you complete a Georgia Advanced Healthcare Directive, you're doing both at once. You're naming someone to make medical decisions and record your wishes about medical treatment. And this document ensures that if you can't speak for yourself, the doctors and loved ones know exactly what you do. and who has the authority to speak for you. Now, let's start with the medical power of attorney. This one names your healthcare agent, someone you trust to make your medical decisions if you are unable to. It may be your spouse, it may be your parent, someone you feel who may be emotionally present to take care of those difficult decisions. It need not be always your spouse, but again, each situation is different. Without this, a family has to petition in court to be recognized as a decision maker. Again, that takes delays. Living will is different from the last will. Living will is when you're still alive. This will cover your end of life treatment preferences, like whether you want life support, artificial nutrition, or just comfort only care. Again, keep in mind these decisions will affect your quality of life in your last few days. Not just your quality of life, even for your finances that you leave behind your family. You can quickly drain all your life savings and put your family in debt from trying to do something which emotionally they are unable to decide, saying that okay, how can they let you go, or how can they stop paying. And some of these treatments would actually put you in pain and without giving any promising results. So living will is just as important. Then there is a HIPAA authorization. This is different from the Advanced Healthcare Directive, uh, but it is very crucial. It allows the doctors and hospitals to share information with the people you choose. So, for example, sharing this with your spouse, your adult children, anyone you trust. Without it, even your closest family members might get blocked from getting updates or talking to medical team because of the privacy laws. Again, keep in mind, preparing these documents isn't just a legal task, it is an act of love and self respect. Let's take another story. Rachel's story, the cost of silence. Let me share about her. She was a vibrant, independent woman in her late 50s, healthy, active, full of life, and one morning she suffered a massive stroke. She was rushed to the hospital, placed on ventilator, unable to speak and make decisions. Her husband, who loved her a lot, believed she would recover if given aggressive treatment, every medical intervention possible. Her adult daughter, however, saw how much Rachel was suffering and remember her mother saying, I don't want to be kept alive by machines. The two people Rachel loved most suddenly found themselves at opposite sides of a heartbreaking decision. The hospital ethics team got involved because Rachel hadn't completed an advanced healthcare directive. No one had clear legal authority to make the final call. The husband and daughter both had to petition the court to be named her healthcare decision maker. Now, while all this happening, the doctors could only provide limited treatment. They could not act decisively without legal approval. And those weeks were filled with tension, guilt, tears. A family that always have been close is now divided. Ultimately, the court appointed her husband as their healthcare agent. By then, the damage was already done emotionally, financially, and relationship wise. This tragedy could have been avoided with one simple document, Advanced Healthcare Directive. If Rachel had clearly written her wishes and appointed a medical decision maker, her loved ones would have known exactly what to do. There would have been no court delays, no painful arguments, no uncertainty about honoring her voice. Planning ahead doesn't always take away control. It gives you and your family peace of mind when they need it the most. Now that we have covered wills and healthcare directives, let's talk about revocable living trusts. Well, again, there are different types of trusts. There is irrevocable living trust, a little bit more complicated, and there are some tax implications as well. And there is also like creation on death. You don't have to create a trust, but you can put in your will that irrevocable trust is created based on instructions in your will. Again, I'm not again going into those details as well. So the simplest one is a revocable living trust. It is a legal entity you create during your lifetime to hold ownership of your assets. The things that, like your home, your business, your investment, and you stay in control as a trustee. You can change, you can cancel it anytime, hence the name revocable. The main advantage, again, it doesn't go through the whole court probate process. When you pass away, the assets in the trust directly transfer to the chosen beneficiaries without court involvement. This means faster access, lower costs, more privacy. So the key thing is, just having a will does not avoid probate. A will still has to be reviewed. It could be contested, it could be probated, it could be countered. But if you have a trust, it avoids all that. Let's take a story. Andrew and his wife were thoughtful parents. They worked hard, saved responsibly, and they had three children, 12, 16, and 19. And they had around $500,000 after their passing. Their goal was simple: make sure the money supported the kids' education, security, and future stability. But here's where things went wrong. They had no trust, only a basic will that left the assets to the children equally. After their death, the courts distributed everything according to the inheritance law. This means the 19-year-old son, legally an adult, receives one third share, around 166,000 immediately. No restrictions, no guidance. He could spend, invest however he wanted. The younger children, however, couldn't receive their portions. They were minors. The court had to create guardianship, the conservatorship accounts, which means lawyers, judges, extra administrative costs. The funds were locked until each of those remaining two children they turned 18. So the result, one child got full control instantly. Two had their money tied up in the court system for years, and none of that reflected what Andrew and his wife truly intended: to manage funds carefully for education and long term support. This story shows why a revocable living trust can be a powerful tool for families. With a trust, the Andrew and his wife could have kept all the children's inheritance in one structured plan, ensured that the funds were managed responsibly until each child reaches adulthood, and then designate even the timing of distributions. For example, some fund for college, some later for buying a home. The key lesson is, without a trust, even well meaning plans can create unfairness, confusion, and lost control. A trust doesn't just protect assets, it protects your children's readiness to handle them. It lets you guide how they receive the inheritance, helping them grow into a financial responsible person instead of just overwhelming them with it too soon. Now, let's review the key steps. What are the things? First, we talked about creating or updating your US will. We talked about completing a Georgia Advanced Directive for Healthcare. We talked about a revocable living trust, especially if you own real estate or a business, and you want to just manage the gradual asset distribution, not like the kids immediately get everything. Then you have to review the asset titles and beneficiaries. Now these are things about your insurance or your IRA accounts or even brokerage accounts that support like transfer on death directives, things like that. It's also important to discuss your wishes with your family members, including your children, including the executor, including the guardian, on why they have been selected and why you're counting on them. Finally, with all this, do consult a qualified Georgia estate planning attorney because it meets all the state specific legal requirements. And keep in mind, don't forget about your Indian documentation either. This is also required, particularly when you have assets, ancestral homes, things like that back in India. So what I do typically is I have a Google sheet, and my Google sheet I basically say, hey, this is my accounts, like bank accounts, savings, checking. I got another section which says these are things that I have debt, whether I have a mortgage, car loan, credit cards, all those things in that section. And like that, I have even utility bills, memberships that I want to cancel. Then I have very basic information, not like credit card numbers. At least the whoever is going to execute needs to know which bank to contact and say that this is the documentation proof that you passed and you want to gain access, or the executor has to gain access. So that sheet is very important. And start preparing all the information that you need for the will, like how you want the assets to be done over time, uh, meaning who is the guardian, trustees. Make sure that you complete the Georgia Healthcare Directive. That's very important. And once again, emphasizing, talk with your family and share documents. And when it comes to the Advanced Healthcare Directive, Give copy to even your primary care physician, so that is they also have a copy. If something goes wrong, your primary physician will be looped in. You may have a patient portal, you can even upload the document there, and you can inform your family that you have uploaded it. So again, just have copies, so that way it is available. Having a document and no access to it doesn't help at all. So as we are wrapping up, I would again would like to thank you for staying this long. Stay focused, taking the step to protect your loved ones. Let's not live in confusion, but let's give peace and clarity as our legacy to our kids.